Okay. Can
All
I?
right,
How do I
I'm
just
going to
draw?
mute myself, Jonathan, and you can take it away.
All right. I don't think this is gonna work, but in the meantime, hello everyone. My name is Jonathan Aris. I'm a landlord, tenant attorney from Miami, Florida. Went to school at Florida A&M University, and got my JD at Michigan State University. And somewhere along this crazy journey, I met Brian Chavis and got involved with Byron and Profit. Met the whole team, Karen, the whole gang, and we started working on how to really empower um, owners of multifamily properties. And so I fit in because protection of your assets is one of the most important things um, that one can think about when it comes to being a good multifamily property owner, operator. So that's where I come into the picture. I help you protect your stuff. And if you like your stuff and you value your stuff, then that's what I'm here for, to help you with that stuff. Today, specifically, I'm going to talk about, and I don't think it's going to work here. Let me see if I can do it here. I'm going to talk about evictions and how the eviction process works. Now, this is probably the least sexy topic of all time, but it's necessary because when you're not getting paid, um, then why are we even doing this, right? By the way, anybody who wants to chime in, I think we have 3 other people besides Karen. If you want to chime in at any point, please let me just raise your hand or just pipe up, and I'll address it. But this is how I teach this. So I have my own course. Um, I call it Eviction University, and I teach people how to do their own evictions. And even if they don't do their own evictions, um, it's it's still helpful because I always say a more empowered client, excuse me, a more educated client is a more empowered client. And so the more you know every step in the process, and the more you can take control of your asset. And I've had situations where I totally deferred to somebody else. And then I realized, maybe I should have researched that a little bit. And so I love it when my clients call me out and ask me questions. It doesn't offend me at all. I don't have that type of ego. But it's this is just a lesson that I've learned, even with doctors, with accountants. It's like, hey, what's that? What does that mean? How does that affect me? And sometimes you get the person and they say, oh, well, we just do this for this reason. And you just pipe up and say, well, do we have to do it that way? And they're like, oh, I guess you don't. Would you like it a different way? And had I just not taken the time to educate myself and ask questions, then I would have possibly had a situation that wouldn't have been as preferable. So, getting to this, this was not my ideal setup. I wanted to be able to, um, I wanted to be able to write with my finger. But if I'm not able to, then we're just gonna go with what we can go with. So, just look at me, and I'll be the one writing in the air with my fingers. So there are 3 steps to an eviction in the state of Florida, and I just want to preface this two things, and then we'll get into the material. Number one, I'm only licensed and barred in the state of Florida. If you're in North Carolina, Texas, uh, California, I got nothing for you. Absolutely nothing. Well, Byron the Prophet is based in Florida. I'm based in Florida. And so the principles can help, but at the end of the day, the law is Florida law. And so you're going to have to take what you can from that. That's number one. Number two is I always recommend that everyone have a professional managing their assets, and that includes an attorney. There are things that you can do without an attorney, but I wouldn't recommend it. Just like I can change my brakes. There's enough YouTube University out there for me to learn how to change my brakes. But do I want to do that? Is that what I want to be investing my time in? No. You are most useful when you are managing your property and making decisions based on that. Whenever you're not doing that, you are losing your efficiency. So let me talk about one last thing. When we think about the laws in Florida regarding multifamily housing, we look to the Florida statutes. Those are the law. Those are the laws in the state of Florida, right? The Florida statute, chapter 83. What's up, Brian? Florida statute, chapter 83, right? That is what's going to navigate, and that's what is going to dictate the laws in the state of Florida. However, what you don't know can hurt you, because after the pandemic in 2020, a lot of municipalities, counties, and cities passed some additional measures to quote unquote protect renters, and a lot of things that are written in the state statute that would have been good law will not apply in most of the major municipalities in the state of Florida, and so you could get caught proverbially with your pants hanging down because you didn't have a professional who's tapped in, has their finger on the pulse of what's going on day in, day out. And the one that I'm referring to is a 15-day notice. It's a 15-day notice to terminate a lease. So I'm gonna try one last time to see if I could write. I want to write. Can I write? This is going to be a little difficult, but let's see how we can do this. Maybe I could type. Okay, I could type something. All right. So first step in eviction is the notice phase. So the notice. So Brian. So number one. The eviction always starts with a notice, right? There are going to be a couple types of notices. Number one is going to be your 3-day. This isn't how I want it to look, but let's see if we can get it. Okay, there we go. Number one is going to be your 3-day. Number two is going to be your 7-day. And then we have formerly the 15-day, but in a lot of places it's 60-day. All right, let me go briefly into this. I'm not going to bore you on this step. But 3 days is for non-payment of rent. If you know anything about managing multifamily property, I'm getting feedback. There we go. If you've heard at least about a 3-day notice. I'm not going to bore you about that, but somebody owes you money, you send them a 3-day notice. The only thing I'm going to say about that is you may think it's really basic. Man. Okay, today is Monday, 3 days. Monday, Tuesday, Wednesday. All right, I'm going to put on the notice that today is Monday, you have to pay by Wednesday. But you would be wrong. And guess what? You have to go back and do it all over again. Why? Because the day you put the notice down, that day doesn't count. So then let's go Tuesday, Wednesday, Thursday. All right, you put Thursday on there. But let's say you forget and then you do it tomorrow. Then you go, okay, today is Tuesday, right? Okay, Jonathan told me don't count Tuesday because that's the day I'm delivering the notice. So Wednesday, Thursday, Friday. All right, got it, Jonathan. I'm good. I don't need you. I don't need an attorney. But you'd be wrong again. Why? Because you didn't recognize that Friday is a holiday, right? It's Veterans Day. So guess what? After Veterans Day is a holiday, you think your 3-day notice is good. You file your complaint in court, and then all of a sudden you get all the way. This is a month from now. You get all the way to that point, all for the judge to say, "Hey, boss man, you messed up on your notice. You got to go all the way back." It's like Monopoly. when you land on that go to jail square, they say, man, go to jail, go directly to jail. Do not collect your rent money for that month. And so that's how it is. So there are nuances in this game that if you haven't done this for a long time, you should know about. Next, 7-day notice. 7-day notice is for non-compliance with a lease. Okay, let me write this in. Non-payment. All right, non-payment. Y'all doing good with this typing? Is it cool? It's cool. Y'all all right? All right. So then non-compliance. All right, let me talk about non-compliance real quick. So this is non-compliance with a lease provision. What does that mean? That means non-compliance with a lease provision. So what does that mean? That means a lease provision. So your tenant getting on your nerves. They chop onions every day, and their apartment stinks, and it's a duplex, and you live next door, right? Or let's say this is multifamily world, right? So you live next door in the building because you decide to home hack, and that's your business. But their joint always stinks. Their unit always stinks, and you're like, hey, I gotta give them a 7-day because they're non-compliant with my nostrils. Well, actually, the rule is, are they non-compliant with the lease provision? And so I actually had a case where we went all the way to the judge, and I forgot exactly what it was that this person was doing. I think it had something to do with how they were handling the trash, but it was not in the lease, and it was something that common sense tells you, hey, this person should not be doing this. It's wrong, but it wasn't in the lease. As a result, we couldn't get them on the 7-day non-compliance with the lease provision. And I haven't lost very many cases. I could count them on one hand, and I could probably count them on 2 fingers, 3 fingers. But that one we lost. I didn't start that case. I took it on, but I should have maybe told the guy, hey, this is probably what's going to happen down the pipe. That's my bad. But the point is non-compliance with the lease provision. So what are we talking about? You say no pets. You say no dogs. This person has a dog. You say, hey, only 2 people could live in there, you and your husband. And all of a sudden, you got Day-Day, Pookie, and Ray in there as well. They're not complying with the lease provision. And you got to hit them with this. And then if they don't comply, they don't fix it in 7 days. They got 7 days. And then if they fix it, the rule says within a year, they can't commit the same grievance. So for example, let's say they kick everybody out, and then 6 months from now, they bring some people back in. They bring Pookie back in. At that point, the rule says you don't have to send them another 7-day. You could just file the eviction at that point. All right. Finally, let's talk about the 15-day. That is to cancel month to month. All right. So why did I say 15-day/60-day? I'm going to reiterate. During the pre-pandemic, 15 days was what you had to give somebody prior to their lease terminating to cancel a month to month. So in the state of Florida, if you have a month-to-month lease, it's going to automatically keep going as long as both parties are cool. Hey, landlord, you cool? Yeah, I'm cool. Hey, tenant, you cool? Yeah, I'm cool. All right, let's keep this going. You know what I'm saying? Like, we got a good thing going. You give me rent, I let you stay. Okay, cool. 15 days. However, this is not written in the state statute, but all the municipalities started basically changing their municipal code to reflect that you need to give them 60 days to cancel. And there are a lot of multifamily property owners who don't know about this. And it makes sense. It's not something that you really Google. Like if you Google it, you're going to find 15 days. And that's why you're here. That's why you're watching this. That's why this is important. That's why it's important to have the right people on your team, i.e. myself, who are going to say, wait, slow down, player, because you're going to go 15 days and then God willing, you don't file a complaint and then think that you're going to get this person out when they're holding over. So the word for somebody who stays beyond the amount of time that they're allowed to stay is called a holdover tenant. So you have this holdover tenant, you give them a 15-day notice, you're going to have to go back, do not pass go, do not collect $200, all right? So first step, notice. All right, let's see if I can, all right, maybe. All right, we're going to keep it rolling. Yep, all right, that's going to work. All right, so the second step. So first, you send your notice. Whatever your notice is, you send it. Good, we're good to go. Then is the complaint stage. So now I'm going to actually file a complaint. What are you going to do? You're going to pay your $115, give or take. You're going to file at the courthouse, and then you have to serve the person. Now, it's important that you get a process server and that you serve this person. This is all basic stuff. And I know Brian's looking at me like, man, you giving them baby food, man. Well, Brian, not everybody's an OG like you. Because some people, I've had people call my office and say, hey, yeah, I served this tenant with the complaint. I sent them an email. They had everything in it. And, or like I gave them all the paper. I left the courthouse. I gave them all the papers. No, you need a certified process server, or the sheriff in your county can actually serve the complaint. Now, what is a complaint? Or what do you have to serve? It's not just a complaint. It's I always include a copy of the notice from this step one, and then something called a summons. And a summons, it just tells people their rights under the statute. All right. I'm going to pause for a second. Does anybody have any questions before we proceed? I want to stop after notice. No, I'm good to go. Keep it pushing. All right. So you give them a copy of the complaint, the notice, and the summons. The sheriff is going to do this, or a certified process server. They're going to get this to the person, and then from then on, they have, if it's a complaint for non-payment, 3-day, they're going to have 5 days to put the money in the registry of the court registry. If they fail to do that, then you win by default. You tell the clerk, hey, clerk, this person was supposed to put in all the money at issue into the court registry. They did not do that. So what happens? You get a default judgment in your favor, and we're good to go. All right. So outcomes. Let's talk about outcomes. Default. All right. No deposit. But let's talk about another outcome. They could answer and say, you know what, Greg? The reason why I didn't pay you rent is because your apartment stinks, right? And I hate it here. And you were supposed to paint the walls, and you didn't paint the walls. And my toilet floods. Greg, I'm going to tell the judge all about what you're doing. All right. So what does the rule say? The rule says that no matter what type of answer they have, if they fail to deposit rent into the court registry, whatever rent is at issue. So let's say it's $2,000. They said, hey, you say, hey, you owe $2,000, and they didn't deposit that amount into the court registry. It doesn't matter what they say. They are currently in default for failing to comply with the statute. Now, that's not to say that judges are not human beings. Sob stories work on these people. They are human beings. They have daughters. They have grandchildren. they have sons. And guess what? Just your luck. Your tenant reminds them of their daughter. And guess what? The tenant talks about in their answer how they have a son and he's special needs. And man, they're going to be out on the street. And that judge just may say, you know what? I want you in my courtroom. I want to talk to you guys. I want to see what's up. So you get an answer, and then the other outcome can be you actually have a hearing. Now, in the hearing, what's most important to remember, if you're me, don't worry about it, because I know what I'm doing. I got this. If you're you and you're trying to do this on your own, what you need to do is document, followed by document, and let's just, for good measure, just round it off with another round of document. Have pictures, have receipts, have text messages, have everything that backs up your position and what's going on. I tell my clients, I say this, I don't know how many times I say this. I probably say this as many times as Brian says, I was born at night, not last night. You know, as many times as Brian says that, what I say is I'd rather have it and not need it than need it and not have it, right? So if the judge said, if your tenant says, hey, look, they the landlord, you know, was a horrible landlord, and they didn't take care of the things that we said we were going to take care of. And then you say, actually, Your Honor, I have a text message from the tenant that says, hey, I love everything in the property. It's great. Everything is going fine. And you have that there. And because you've documented, you have it, whether you needed it or not. So you kill an extra little sapling of paper because you printed an extra sheet of paper. But again, I'd rather have it and not need it than need it and not have it. All right, finally, let's go down here and let's talk about the last phase of the process. The last step of the quick and dirty eviction explanation. So then you have the lockout with the sheriff. I think that's how you spell it. So the judge says, you know what, Greg? Yep, you deserve to be paid rent throughout this person's tenancy and throughout the pendency of this lawsuit. So I'm going to grant judgment in your favor. This person has to be out by Friday. Friday comes and goes. This person isn't out. Then you tell the sheriff in your county, you say, hey, sheriff, I need this person out. This process is very easy, quick, and dirty. What you're going to be given when you get a final judgment, you're going to be called, this is the most important document that you're trying to get when you have an eviction. It's called a writ of possession. That is the document that tells the world, hey, this person no longer can remain in this property legally. I have authorization from the judge that this person has to be out of the property. So after you get your final judgment, you send a writ of possession to the judge as well, and he or she will sign it at that point. Now let's backtrack. Let's say Greg is feeling a little, how should I say it, froggy, right? So if you're feeling froggy, Greg, then jump, right? So Greg is feeling a little froggy, right? And he's like, look, I'm tired of you, Mr. Tenant. You taking all my money. You ain't paying me no rent. Man, I got kids to feed. You know what I'm saying? They Crocs, is the strap on the Crocs is busted. They can't even go into sport mode. You know what I'm saying? So I'm just going to go over there. I got, Brian been working out. So I'm going to go over there. Me and Brian going to go we're gonna knock on his door and be like, you gotta go. And if the tenant isn't there, guess what? We're gonna change the locks on him and throw all his stuff on the street. If you do that in the state of Florida, then you, Greg, are an ignoramus. Don't do it, because you will have to put that person back in possession, and you will be charged 3 times. I'm going to say it again, 3 times the amount of rent that is owed for every violation. So basically, they owe $2,000 a month. If they bring that any violation to the judge, that's $6,000 that you have to pay per violation. Just because you were impatient, you didn't want to wait for this writ of possession. You said, I'm going to take matters into my own hands. Do not do it. That is called a self-help eviction, and it is illegal in the state of Florida. You cannot change the locks on somebody. You need a writ of possession. You cannot, if you're responsible for providing utilities along with the rent, you cannot shut off utilities. You need a writ of possession. You cannot. I'm good. I'm good again. Okay. I was saying you cannot block somebody's ingress and egress to the property. I had a case where my client, we won this one, but my client, she didn't change the locks on the property, but she locked the fence that led to the person's property. And the poor little girl, she was a little girl. Poor little girl was jumping the fence. She was jumping the fence to get in and out of her house. And I was like, yo, you can't do that. You gotta either unlock that gate or give her a key to it. You can't. That's engaging in self-help eviction. You need a writ of possession. If I was in a class where people could all speak, I would say, let's all say it together, people. 1, 2, 3. Writ of possession. This is the key document that you want. So you take this writ of possession to the sheriff. You put in Dade County $115 in their hands, and you say, go to work. And they take it from there. They will usually inform you when they're going, and it's your responsibility to show up at the property with the locksmith or change the locks yourself. And that's it. That property is in your possession. Now, $115 is Dade. I think Broward is $85. The amount doesn't matter. The point is you go, give them the amount that they say, and show up when they say with whatever they say. Because at that point, time is money, and you want your property back. And that's a quick and dirty of an eviction in the state of Florida. Now, I'm assuming that you guys probably have some specific questions about things that have happened. I'm here for that. I got years in this game. I'm not new to this. I'm true to this. So, and watch the first question stump me and be like, oh, I don't know. I never heard of that before. But just in case, does anybody have any questions about this? This is an eviction for non-payment of rent. Of course, it's one for non-compliance or one for a holdover month to month. It'll be very, very similar, but of course, you won't have the defenses that you have for non-payment if the person continues paying you. So, any questions? Greg says amazing event. Greg, I'm glad you were a great example landlord for this. Should I keep going or should I mean, we've been on it a couple, how long? I don't have a timer here. Keep going. Okay, let me talk about a few. Let me talk about a few do's and don'ts. I already talked about do not engage in self-help, right? That's one thing. Let's also talk about, I already talked document. You want to have copies of everything. Let's talk about this. In the state of Florida, oral leases are valid. You can have an oral lease. But do I recommend it? Never, 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 never. All right. Here's the reason why. If you can, in theory, contract away almost all of your rights, and if you don't have that set up, then that person, the rights in which the rights that you have as a landlord and the rights that the tenant has, they're fuzzy. And so when it comes to court, this is going to be more expensive and more time consuming because the judge is going to have to parse out, wait, how does this work in this situation? Because normally they would just be like, well, what does the lease say? All right, the lease says this, so that's what it is. At that point, it's going to be fuzzy and it's going to be more time consuming and more expensive. Somebody has a situation where it's an oral lease and it's a he said, she said, they're going to have to pay me. They're going to have to pay me real good because at that point, I'm going to have to basically recreate the record and look at the conduct of the parties. And I'll have to say, man, in February, you guys behaved like this. You sent them a text message. You said it was cool that they paid on this day. Then in March, then you said, no, you had to send me an email when you're going to be late. Like I had to reconstruct the behavior of the parties and basically show that to the judge. So always make sure everything you have is written. Here's the other one, kind of along those lines. What I said is here in the state of Florida, if you have a lease and it's ending and you guys continue going on, you have a month-to-month lease. At that point, the old lease controls, but you always want to have somebody on a current lease. That way, you match the values of rent that are current that day. You don't want to be charging somebody what you charged them in 1988 when Greg was a young whippersnapper, wooing Karen around these streets. That 1988 rent, that was $45 a month. That was good living back then. You know what I'm saying? Now in Miami, it's gonna cost you at least 4,800. You know what I'm saying? So the point is, make sure that you do not slack on knowing when your lease is gonna expire, so that you put somebody on a new lease, and you don't let that happen. Let me say this one last thing, and then I'll see if anybody has more questions. I'm a pastor, and I'm a Christ follower, and that's what my life is dedicated towards. This is just what I do. I ain't gonna do this forever. I'm gonna be serving Jesus forever. And along with that, people are like, man, so you kick people out on the street for a living, man? That's not very pastoral of you. And that is one side of the coin. That yes, there are people who are slumlords, and I don't represent those people. And I know that if you're in BRP, trying to get some BRP education, that's not you either. You want a well-run property, but at the end of the day, you're trying to feed your dreams, fund your dreams, and do things the right way, right? So I just want to talk about that side of the coin in terms of, man, when you run an efficient operation, it ultimately helps people. When your properties are run well, when they're clean, when repairs are done, when you listen to the feedback of your tenants, and that actually improves people's lives. When you don't have boundaries and you let things slide, and all of a sudden you have a month-to-month lease, and then the terms of your agreement are fuzzy, and you putting out notices willy-nilly, and then you have to like go back, and so the person is like, oh, I wasn't eviction proceedings, but now the judge dismissed it because the landlord did the wrong thing. It creates confusion, and it's not an efficient operation. It's not the way you want to run your life, and especially not your multifamily asset. And so, man, the end of the day, you have to look at it like, I'm improving lives. I'm giving people a place to live. Man, some of my apartments, I have so many memories. when I had good landlords, I got good memories there of Christmases and of, first steps, my kids' first steps. Like those are the types of experiences where they have a good, safe environment. Furthermore, we're all trying to make it, and I represent some multifamily landlords. They're not like these big time humongous companies. They're just people like, hey, I invested my money wisely and I was able to buy a quad. I was able to buy an 8-door building. I was able to buy a duplex, and I'm home hacking and I'm on one side. I had a situation like that. And this lady was a social worker. She wasn't Donald Trump, with tons and tons of doors. She had one door. She was a social worker making, I don't know, probably less than around 40 grand or something like that. And she had cancer. And she would cry on the phone and be like, man, this woman next door is making my life so hard, because she would hear the lady and the lady would like pound on the wall and start yelling and be like, I ain't going nowhere, and to help her was very gratifying, because you realize, we don't, just because we're blessed enough to have this asset doesn't mean, man, we do everything the right way or we're slumlords. Sometimes this woman, she needed that money, the rent money that she wasn't getting paid, to pay her mortgage and also to help her pay for her treatments for cancer. And so I just want to talk about the other side of the coin and say that it's imperative on you to make sure that you educate yourself with talks like this, but also with everything else that BRP has, in order, man, to give your tenants the best experience possible. So that's pretty much my spiel. I saw a message from Greg, said, do text messages count at a court hearing? They do at this level. So you go into federal court with some text messages and you don't lay a proper evidentiary foundation, then that's going to get kicked out. But at this level, so evictions, this is a little nerdy. You guys don't have to remember this, but there are 3 levels in state court. There's circuit civil, which is the highest. There's county court, which is in the middle, and there's small claims, which is the smallest, up to 8,000. So this is in the middle, county court. And judges recognize that a lot of these tenants are going to be pro se, which means they're going to be unrepresented by counsel. As a result, they try to not make people's lives too difficult. And if they have some type of evidence, like a text message, if you have it printed out and it's clear who it came from and when it was delivered, a lot of judges will take that. Good question, Greg. Anyone else have any question? All right. Now, like I said, this is quick and dirty. This is not exhaustive. I don't recommend that you try to do this on your own. Furthermore, in the state of Florida, if you have an eviction and you do it on your own, you can only, let me see if I can move this. Can I move this toolbar? Let me back up, zoom in. All right. You can only, remember I talked about these 3 outcomes? Outcome one is a default. Outcome 2 is an answer without a hearing, and outcome 3 is a hearing, right? So if they answer and your asset is owned by a company, you have to get an attorney at that point. Like, and this is not advice. This is the law. The law says that a company cannot represent itself in court. But there's a little caveat when it comes to eviction law where they say, okay, a company can represent themselves in court until there's an answer. And this is the only time where a company can represent itself in court. If you go to circuit civil and it's let's just make up a company, Starbucks versus Greg. Starbucks in that case would have to they would have to file that lawsuit with an attorney, because at that point it's circuit civil, or at any level really, except for small claims. So small claims and this eviction court, you need an attorney. So that's the need. And furthermore, I don't recommend that you own a property in your own name. So your property should all be owned by a company, by your company. And so you need an attorney at that point. But prior to, even at this level, when it comes to a notice, you should have an attorney on deck. And that's what I'm here for. So anybody who might be able to benefit from picking my brain, I invite it, and that's what I'm here for. So that's all, y'all.
Jonathan, did you put your information in the chat?
Oh, sorry about that. Karen, are you talking to me?
Okay, yeah, put your make sure. How do we got to make sure we have your information.
Oh, my information? Yeah. Hit me up on the gram. You know what I'm saying? DM me on the. Nah, I'm just kidding. No. I don't even go on Instagram. I'm being silly. If you want to contact me here, let me put my information in, and they could, of course,
it'll be by Profit Education. Jonathan's profile will be there as one of the instructors, and you'll be able to access the Onyx group directly from there. But in the meantime, in between time, for right now, for those of you like Lavinia who are on, who are the licensed agent, please share Jonathan's information to the best landlord tenant eviction attorney out there. Please share this information for all those who are dabbling or in property management at a high level, medium level, or entry level. Jonathan is their landlord tenant eviction attorney.
Yeah, and let me just say this, Brian, related to what you just said. You have to, man, you have to do a cost benefit analysis, right? It costs to hire me, right? And they're probably less expensive people than me. I've seen some bargain basement attorneys. Some of them are really not attorneys. And can you get this done? Maybe. But the times where I've seen where people mess it up because they try to save $1, that's not your level. That's not the level of the people who are in buy, rent, and profit education. Man, you pay for services, you pay a quality broker, you pay a quality bookkeeper, accountant, you pay a quality attorney to get this stuff done. That's the level you're playing at. Now you want to play, at the JV level, then yeah, try to do everything yourself. But we all know that a jack of all trades is a master of none. And if you want to master, managing these multifamilies, focus on that. Focus on what's going forward and your next plan. Not, hey, person in 42A owes me $500, so let me go peel off of moving the vision forward and go deal with this. So, yes, contact me. A lot of times I give free advice. There are a lot of times, man, I won't take your money because I'm like, you could do this on your own. It's just send this person a text message, give this person a phone call. You can handle it. But then when it's real, when I'm like, no, I should really get involved. It's because I should really get involved, and you're probably gonna mess this up. And that's the way I roll.
Hey, listen, if you're about business and you're about scaling, which everyone in here is about scaling, and you're about growing your business, you put people in. If you're the smartest person on your team, then your team is in trouble. So, trying to be, I'm telling you, because I've done this from the ground up. I've done this literally from the ground up. Jonathan will tell you, my track record will tell you. You don't do this from the ground up by trying to do things yourself and being a jack of all trades. You do this by you scale quickly by bringing in great team members such as, and that's the way you scale, guys. And that's why Buy It, Rent, Profit Education was number one, built, and number two, why I sought after the best of the best to not only do training but also provide services. So you can a team like Jonathan, the big boys, as Jonathan said in his in his training today, he talked about a lot of the bigger companies. You have access to everyone that these bigger companies have access to. You have access to an attorney. You have access to bookkeeping. You have access to all the tools and resources they do. So there's no excuse. The playing field has been leveled for you. So take advantage of it. Thanks, Jonathan.
Can I say this one thing?
Uh-huh.
And even the big boys try to save a buck every once in a while. And there's an attorney, Brian always talks about him. He's very well known in the state for in the eviction space. And the first case I had against him was because this property manager messed up, tried to cut a corner, and I was introduced to the guy. We won on that case, but it's like, just because you have resources, it doesn't mean that you're immune from this. A matter of fact, it's the opposite. It means that you can hedge, or you can buffer. You can make mistakes and it won't hurt you as much. But I imagine the people at this level, like, it's important to have your team in place, because if you take a hit, it might hit you a little differently than if you have 500 1,500 doors. So, man, make sure that now, this isn't for the big boys, this is for now. Build your team now. Make sure you have your realtor now. Make sure you have your finance guy now. Like, it's not like, oh, when I get to a certain level. No, you can't afford to not to. You guys are fantastic. You raise my self-esteem. You raise me up.
And with that, we will say goodbye. When he starts singing, it's time to go, ladies and gentlemen.
Peace out, y'all.
Thank you.
Thank you, brother. God bless.
All right, guys. Take care. Talk to you soon.
Thank you.